Welcome to the committee, Senator.
Thank you, Madam
And thank
Chair.
you for the work that you've done on preparing this legislation.
It's my pleasure, just trying to help the people out. My name's Peter Riggs, Senator from District 3. Thank you for taking the time to look at what myself and some of the other senators have put together. I want to start by reiterating something that the good chair said when she started out. Just stole a lot of my thunder, actually.
All right.
No,
I wouldn't want to do
no,
that.
it's actually perfect because it's incredibly relevant, and it's something that I think everybody needs to think about as we go through this. In the Idaho Health Freedom Act, it says it is hereby declared that the public
Senator,
policy.
may I just mention to the committee that I did present everyone with a copy so they can.
Great, thank
go
you.
for
I just
that. But
wanted
if
to.
you would read through it.
I just
please.
want to, one section that I think is most important to look at as we consider how we're going to deal with this going forward is the section that says it is hereby declared that the public policy of the state of Idaho, consistent with our constitutionally recognized and inalienable rights of liberty, is that every person within the state of Idaho is and shall be free to choose or decline to choose any mode of securing healthcare services without penalty or threat of penalty by the federal government of the United States of America. I agree with the good chair that this should be unnecessary. And I think given a legal challenge, there's a good chance that our existing statute protects the people of the state of Idaho, both employees and employers. But one of the reasons I got involved is I feel that if there's going to be an adjustment to the language, then it needs to be done. It needs to be properly constructed, and it needs to protect the freedoms of the people of Idaho, both employers and employees. And as much as it seems counterintuitive, sometimes protecting freedom doesn't always mean fewer laws. The last 2 years have been tough for everyone, but to add insult to injury, an incredibly adversarial environment has emerged between employers and employees. And more than anything, I want employers and employees to work together to get through this issue themselves collaboratively, but I don't all the time get what I want. So there are already a number of baseline labor regulations that businesses are legally required to follow. So the argument that we should not be regulating businesses went out the window a long time ago. The key is not whether or not we should be regulating businesses. The key is making sure that when we consider new regulations, they will not create undue burden for businesses or their employees. We need to do our best to try to make sure that there is a level playing field for all of the people of Idaho to work and build their lives on. One of our duties is to protect the freedoms of the people of the state of Idaho. And I've heard business leaders saying, please don't do anything regarding this because we don't want Idaho law to conflict with federal policies. Now just think about that for a second. Our business communities are feeling so threatened by the current mandates that are thankfully on hold for right now, that they're saying, please don't change the law, not because of it might conflict with federal law, but because it'll conflict with federal policy. And the moment our people start fearing federal policy more than they rely on the statutes of our own state, we know we've got a problem, and that's when we have to consider stepping in to do something to change that. That's why, as much as I agree with the good chair that this is probably unnecessary, but in a legal fight, it's always good to have clarification if necessary. And so the language that I'm proposing just gives more clarity to the Idaho Health Freedom Act, reinforcing some of the ways that differences in medical philosophy should be handled. And it puts a considerable amount of responsibility with both employers and employees to work together in this broad framework to come to a collaborative solution. All this language would say is that you simply cannot fire somebody for not choosing to get the vaccine. There must be reasonable accommodations made if their medical philosophy differs from that of the corporation, then reasonable accommodations, personal protective equipment, COVID testing, antibody testing, something along those lines. But the business and the employees need to work together to figure that out. All we're setting is the baseline of saying it is unfair to start prying into people's medical histories, their medical choices, and then threatening them with termination if they don't see eye to eye with the philosophies of the business. And so with that, I'd stand for questions.
Okay. Thank you, Senator. Questions of the committee? Senator Stennett?
Thank you, Madam Chair. Good morning, Senator.
Morning.
I'm just trying to get a little clarification from something that you just said, that there's a little more fear by employers about what's happening with this in federal law. And you said that there's a difference between policy and law. And as far as talking to my lawyer friends, I think they're the same thing. So I'm trying to get an understanding of a little clarification of what that difference is, because it's not unprecedented that employers and employees, but employers have been following federal and state law for a long time to give them guidance and to protect the workforce and to protect the consumer and any number of things that we do it for valid, good reasons. And as an extra question to this, how you see the difference between policy and law, according to what you've said with the employer conversations that you've had. But what would they do with this when they have conflicting employees who feel like their own rights, which are in conflict with each other, are evenly served under that employer's tenure in his company?
I'll try to get to your, thank you, Madam Chair. I'll try to get to your multi-pronged question, and stop me if I miss any part of it. Fundamentally speaking, there's going to be a legal weight difference associated to formally passed laws and things that are executive orders, which are just policies that can be easily rescinded and arguably more easily fought by the people. And so that's basically what we're talking about right now, is the fundamental difference of that versus a formally adopted legal statute, especially here in the state of Idaho. So if that makes sense or not. And once again, it all comes down to, if there is a lawsuit, who is going to decide which way? And the old joke that I'm sure Senator Burgoyne knows, if you get 3 lawyers in a room and ask them for an opinion, you'll get 5 opinions. And so it just comes down to what will come out during any sort of lawsuit or consideration of the results. And I'm not saying, now to continue on, I'm not saying that this is going to be an easy solution. I'm not saying that this isn't going to, it's not going to alleviate conflict between the dictates of a business saying, here's what we want to do to keep our employees and our customers safe. Here's how we want our employees to conduct themselves. There's going to be friction there between business philosophies and personal philosophies. But one of the things that I feel it is our responsibility to do is to help provide the framework for people to work together to get collaborative solutions. And that's one of my big concerns that I see right now, is the fact that that isn't taking place. The Fifth Circuit put a stay on the OSHA mandates, and they, with a fairly strongly worded rebuke. And yet there are still businesses saying, we think this might be coming or not, and so we're just going to, and I haven't been in the room, so whether or not, how many of these people were, fired because they wouldn't take the shot, I don't know. It's just one of those things where you hear enough stories of, I lost my job because I wouldn't get the shot. Businesses are afraid of a federal mandate that isn't even empowered anymore. And there is this growing divide between employers and employees, business and the people, and it's unsustainable for our community, for our state. It's only going to cause harm. And as much as I don't want us to have to get into this fray, there seems to be an unwillingness for the two sides to come to reasonable conclusions themselves. So at that point, we have to step in and say, here are the rules in which this game will be played, how the game goes, how this compromise ends up getting worked out from both sides. That is ultimately up to those people and those businesses, because the majority of businesses, they're not over 100 people. They're not subjected to this OSHA mandate, even if it continued on. But there's just a change in the way businesses are treating in customers, employees, and there's a big change in the way employees are treating their employers. It's neither one of them is at their own personal kingdom to do what they want. It all is supposed to be a collaborative organism that is kind of like the government. It's for us to help us to do what we want it to do, and that's starting to erode. And we've got an opportunity here to say, we're going to put a little something here to help try to tamp things down, but it's not going to put undue burden on either employers or employees. But you can't make any knee-jerk reactions, just fire people. You can't do these types of, we like I said, we already have a lot of these baseline regulations saying you can't discriminate against red-haired people. You can't say you're fired because I don't like gingers. I mean, you can fire me anyway, but you just can't say that. The bottom line is we have to come up with something that will help get our people back working confidently and ready to go without the fear of these federal policies either finding them out of business or just forcing them as employees to no longer be employed.
Understand it?
Thank you, Madam Chair. Just a quick follow-up. I totally get where you're trying to get on this and understand the difficulty for employees and employers. I'm just trying to see how this works. I mean, we're in the middle of federal consideration on all of this, and this is being presented to us now. How does this have any teeth if the state goes forward with this and without knowing the outcome of a federal decision? And how does I'm just not clear how I understand where you're trying to get, how this helps us get there functionally without crossing all kinds of existing policy you've mentioned, or that the content is good. I'm a little confused if you could, how you see this, the state could apply this in the current conditions with what's happening in federal court and maybe a potential federal decision. Sure. I do understand the employer's hesitance on this because it is an unknown until some determination is made. So how is this going to step in the middle of it, or how is this possibly going to continue if a decision is made? How does that function?
Senator Riggs.
Senator Stennett, the state doesn't enforce it. The state, that's not our job. Our job is to make sure that the playbook is set. If an employee feels that their employer has violated this, if an employer feels like they have employees that are not abiding by it as well, they won't conduct themselves within the policies of the business to keep employees and customers safe. Then they have legal recourses for that, and it's our duty to make sure that basically the law is there for the interpretation for those singular issues as they occur. But enforcement of this is not a state responsibility, and it's not our responsibility as the legislature.
Thank you.
Thank you. Any further questions? Senator Winder.
Thank you, Madam Chair. Thanks, Senator Riggs, for bringing this and working on this. One of my struggles in this whole process over the last 6 months or so, since several of the local healthcare providers basically brought this to the forefront by saying either get vaccinated or get fired. I think they've subsequently, with the crisis standard care, have rescinded that. It's kind of been a waiting or a holding pattern, but we've heard from some of our employers of having certain employees that need to travel, for instance, internationally, that in order to do their job, they need to be vaccinated to get into foreign countries to do the job they've been hired for. help me understand how this particular bill strikes that balance, provides a sweet spot, recognizes the fact that we already have some pretty strong anti-vax laws in Idaho, but how do we actually balance this out?
Madam Chair.
Yes.
Very delicately, Senator Winder. That's part of the ongoing complexity and why even 2 years into this, we don't have any one size fits all. Everybody's happy with this fix because we are dealing with an unprecedented medical situation in a way that has caused us to see both the strengths and weaknesses of our communities, our business communities, our government, our people. I mean, it's caused a lot of strain on everyone, and that's where I think that when we take too firm of a stance on we're going to do nothing, or we're going to do something that is all to the benefit of the employers or all to the benefit of the employees, that's where we start to tip the balance in an unacceptable way towards consequences that we can't possibly be prepared for. That's why I think that when we look at any legislation that we consider regarding how to deal with this, it needs to be considered with the idea that the outcome needs to be not detrimental based on the decisions that we have made. That doesn't mean that every business and every employee is going to come through this exactly how we would have wanted them to. But it's our responsibility to do the best we can to give guidance and then let the people make those decisions on their own. If a business requires somebody, the job is to travel to foreign countries that have far more stringent vaccination regulations than the United States, then that's a serious business performance issue. And it would be unreasonable for the employee to think that they can go to a country that has vaccine mandates and flout their laws if it's against their personal belief. And it would be unreasonable for the business to have to keep on a person that is unwilling to do that part of their job. And so, but that needs to be, the details of that need to be worked out between the employer and the employee. The moment the state legislature or the federal government tries to get involved and decide the nuance of each of those interactions and the outcomes is the moment that it gets away from us, because we will screw it up. If it is up to us to do this and decide every outcome, we will get it wrong. There's just no way we can handle crafting legislation that is specific enough and broad enough to work well in each of those situations. That's why we need to do the bare minimum to set the framework and then let the people work out the process on their own.
Senator Winder?
Follow up, please. Thank you. I couldn't agree with you more. This is a complicated issue, but the specifics of my question was, how does this particular bill strike that balance that you talked about?
Senator Riggs?
Senator Winder, the way that I see it striking that balance is if a business does a large amount of business traveling to a country that has more strict vaccine mandates, but they have an employee that used to do that is unwilling to get vaccinated, there has to be work to between the two parties to determine if there is a suitable adjustment that can be made. Maybe this employee's route can be shifted to a country that doesn't have a vaccine mandate. The bottom line is it forces them to work through it, and if a compromise can't be reached, then the outcome is, because in the language that I've proposed, it talks about reasonable accommodation. It can't be done forced upon the business if doing so would cause undue hardship. and keeping on an employee that can't do their job because of the business or the employee's unwillingness to be vaccinated, that creates an undue hardship that then starts to get outside the bounds of this legislation. But what I think that we would like to do as, stewards of the law is make sure that if there is an employee that their job regularly takes them to a country with strong vaccination requirements, we don't want the knee-jerk reaction from the business community to just fire all those people wholesale. We want there to be discussion and effort to make compromise and see if there's a way to get around this issue. And outside of that, that's what we can hope for with the legislation that we put forward. And it won't always go that way, but there's nothing legislatively that we can do about that either. That's why I look at it as just setting the framework and then letting the people and the legal system determine how it goes from there.
Thank you. Senator Burgoyne?
Thank you, Madam Chair, and thank you, Senator Riggs, for this. It's intimidating to wade in even to the shallow end of this pool, and you've waded in a ways. And I take your advice about handling it delicately. When this pandemic started, it strikes me that our responses to it were involved a lot of gross motor skills, and in some areas we've managed as a society to get down to some fine motor skills, and we're still working on that. And it's probably a time for some delicacy with respect to these issues. I have a couple of comments. One is I just wonder about perhaps a little different approach. Currently, the Americans with Disabilities Act, a federal law, requires employers to reasonably accommodate medical conditions that might militate against taking a COVID vaccine. Title VII of the Civil Rights Act of 1964, a federal law, currently requires employers to accommodate religious objections to vaccinating. And the Idaho Human Rights Act, as a matter of state policy, requires that employers accommodate religious objections and the medical issues as well. And those federal and state laws already relate to the issue of undue hardship. And so with respect to the language in subsection 5 on page 2, lines 6 through 15, to the extent that different words might lead to different or conflicting decisions in either the Idaho or the federal courts on these issues, I was trying to think, well, how can we deal with that? And one of the things that occurred to me is that we might use some of that COVID money to be sure that employers and employees are fully apprised of all of their legal rights here. The other thing on just one further comment, and Madam Chair, if the Senator wishes to comment on my comments, I would appreciate it. I see the language on lines 36 and 37 at the bottom of page 1. No employer shall discriminate against any employee who chooses not to receive a COVID-19 vaccine. The employment lawyer in me immediately leapt to the situation where the employer wishes to discriminate against the employee on the basis that the employee did a lousy job, and they either wish to reassign or to discharge the employee because of that. So I'm hired and I'm supposed to make 100 widgets an hour. That's the standard. My coworkers do it, and I'm only capable of making 75, and they want to let me go. But it's coincidental that not too long before I was let go, I also got the COVID vaccine. And it struck me that this language, and I suspect inadvertently, says the employer can't discriminate against me because of that performance issue because I did get the COVID vaccine. And I thought that maybe it might help to say something like it, no employer shall discriminate against any employee for choosing to not to receive the COVID vaccine. And that would make it clear that it's kind of an anti-retaliation provision, that you can't fire me, you can't reassign me because I took the COVID vaccine. And my third comment was, it wasn't clear to me from the language that subsection 5 modifies subsection 1 on the anti-retaliation. In other words, if it is an undue hardship to keep me because I can't travel to British Columbia or to some other foreign country that has a hard and fast vaccine mandate, it's just not clear to me that what is in subsection 5 says that my employer cannot take action because I refused to vaccinate. And I think those are just really minor kinds of word choice issues, but I wanted to get those out there. And but I think it seems to me that a lot of us are trying to do the same thing. We don't want Idaho's private sector employers and employees to be stuck in a box they can't get out of with outcomes that are not Idaho outcomes and are not conducive to keeping our economy on track.
Do you have any comments back?
Yes, Madam Chair. Senator Burgoyne, thank you. Those were good comments, and I don't disagree with you at all on the nuance of the words and how to make sure that it is as appropriately crafted and enforceable as possible. I appreciate the feedback, and we'll definitely look into that. And I think that your comments also towards making sure that both businesses and employees understand the legal framework that may be available to them through existing laws, both state and federal, could be invaluable in this time that we're going through right now, because there's a lot of people that are just it's been all too much, and they aren't necessarily aware of the subtleties and the diversity of laws that are available to support them as much as somebody like yourself. And so I think that anything we can do to kind of help make both businesses feel more confident in their ability to do business and employees in their ability to make sure that they're being treated fairly, I think that's important.
Seeing no further questions at this time, thank you very much, Senator Riggs, for the work that you've done on this and the work that you'll probably be continuing to do on this. And I think you gave a really great presentation of your legislation, and I'd like to thank you for